Okay, well, welcome back. Ellen, it's a good sign when people come back after the break, so it's a good thing. I'm Bill Baldiga. I'm pleased to host the next panel. Also, as the chair of Brown Rudnick, I just wanted to, again, say welcome, and it's great to see so many good friends at this first conference. I think first to have our panelists, Emily, Alex, and Maurice, perhaps introduce yourself.
Shall I start? So, hi everyone. I'm Emily O'Neill. I'm the General Counsel for the UK for Deminor. We're a European headquartered litigation fund.
Maurice MacSweeny from the investment team at Harbour Litigation Funding, where I'm an originator, talking to law firms and others about investment opportunities and working those up. And Harbour, we might have been introduced earlier in the day, one of the largest privately owned litigation funders with about $1.5 billion under management.
I'm Alex Garnier, founding partner of Northwall Capital. We're a generalist private capital investment fund with a substantial legal assets strategy. We're about 1.2 billion AUM today and have plenty of exposure to this sector.
So one of the things we thought we would focus on is portfolio fundings, which all of you have some experience in. There's a lot of discussion about that, and something we've thought a lot about as a firm and have some experience in. What is driving, if I could, the rise of portfolio fundings as opposed to one-off? Maurice, do you want to start with that?
Sure. I mean, I think one of the big pros of portfolio funding for funders, at least, is that it gives really broad access to the whole litigation market. And I think, the market opportunity for many funders has actually been quite small if you think of the totality of litigation that's going on. So many funders fund cases at the larger end of the market. Not all. There are some that have very successful business models funding smaller cases. But I think, portfolios are a particularly good way of grouping together smaller cases that may not be that suitable, or you may not be able to fund them on a single case basis. So by grouping them together, I think, for funders, there is a real interest in putting together these sorts of portfolios. I couldn't quite find it. There was a great statistic I saw when I was trying to remember where I saw it for today about the sort of volume of litigation going through the UK High Court, and you have this sort of small bit at the top of the pyramid of the kind of cases that may be suitable for traditional single case funding, and it sort of very much broadens out. It's a very sort of broad pyramid at the bottom with the other cases. So by grouping together portfolios, cases in a portfolio, I think you can really access a broader range of market opportunity. I think the other thing that's driving portfolio funding is really, it's a relationship development point. And I think that there are, between law firms and funders, good relationships. And I think portfolio funding, it feels to me at least, is a natural extension of that pre-existing business relationship between a funder and a firm, or a funder and a corporate. So one of Harbour's lockdown projects was to look at our data, and I think it was pretty clear from that the best referrals we had were coming from those firms that we had a good relationship with, where we'd funded many cases together. And I think from the firm's perspective, if you have that portfolio in place, you're able to go to market. It's quite a useful business development tool for firms, that you can go to your clients and say, we have access to this pool of capital, we have speedier processes agreed, and probably better pricing as a result of that volume of business. And then I think the funder, the pro for the funder there is that they're likely to get first dibs on the firm's best cases. I mentioned better pricing. I think pricing is a sort of pro and a con. I guess it depends on what side of the fence you're sitting. But one of the real pros of portfolio funding for funders is the ability to cross-collateralize. So you can spread your risk across a number of cases in a portfolio, and the losses on one case can be made up by wins on another. So from a funder's perspective, you're able to get your investment back, even on unsuccessful cases, before you start distributing recoveries to the funded party. The con, I think, it might be a pro for law firms, is that the reduction in risk often comes with a request for a reduction in pricing. The risk is lower, and therefore, the take that a funder takes should be concomitantly lower as well. And so I think, that within a portfolio context, having lower pricing is great, but it comes as a result of being able to spread the risk. And I do think there's sometimes a difficult conversation, after you've funded a portfolio case. If you're looking at a single case with the same firm, they sometimes say, well, can we not benefit from the same sort of pricing? But I think the sort of pricing issue with portfolios, that it is that spreading of the risk that generates the lower pricing. I think just thinking, one other sort of thing that may limit, I suppose, the growth of portfolios is that I think some corporates and law firms think that it can be a one-size-fits-all solution. And I think from a funder's perspective, it makes it quite difficult to underwrite when you have a real variety in the subject matter and the type of cases that you want to put into that portfolio. We heard earlier, John from Burford was talking about corporates, and corporates may want to fund a defence. And really the only way to do that is to put it within a portfolio of other cases. You may have a corporate that wants to include cases which are less meritorious, and so by grouping those into a portfolio, you can understand the desire from the corporate to do that. But from the funder's perspective, obviously it does increase risk and probably depresses returns. But I think we will see more portfolios. I think that trend will continue. I think that will be driven by kind of greater greater willingness of firms to take on risk, want to work more on risk, and funders can help with that by having cases in portfolios. But I think variety in cases does make that a bit tricky. It would be nice to think that litigation was predictable, but I think we'd all be out of a job, I think, if it was.
Yeah, I don't see that happening too soon. Emily, for a funder, the risk of adverse selection in a portfolio is a significant one. How do you think about that in advising your client?
So I think it depends on what the portfolio is. So if you're looking at a kind of a closed portfolio of cases that are presented versus something where there's still some book building involved, so there's going to be different approaches. So if you're looking at a sort of a closed portfolio, what are the claim types? So if it's a type of claim, then it's a lot easier to look at the portfolio and to assess the risk across that by basically looking at track record and then diligencing some of the cases within that. But if you're looking at more of a collection of different cases, as Maurice was talking about, I think that's a lot more difficult, and you then need to do some due diligence on each individual one, because at the end of the day, you're not going to really cross-collateralise between the portfolio cases if you don't have a balance of risk within that portfolio. And in order to assess the risk, you'll need to look into the cases in a bit more detail if there are some big differences. So I think that's sort of worth bearing in mind. If it's a portfolio where there's some more book building that needs to happen, or there's going to be more cases added, it's really a matter of what's the process for adding those, and who selects them, what's the process that needs to be gone through, and then will they fit within the model or not, is the question that we apply. So I think it really depends on the type of portfolio you're looking at. And then I think it's important to understand really the strategy. So why is this a portfolio? Because everybody needs to be on the same page for that to work properly. So if it's a kind of a collection of different cases, so maybe it's a law firm bringing a portfolio, then are the law firm and their clients all in alignment? Because actually, if there are some losses, then the successful cases, they may not realise the same sort of level of return at the client level if the portfolio structure has a waterfall that does properly cross-collateralise for the funder. And I think the last thing we look at is just sort of the practicalities in managing that. So how will the reporting work from the law firm to the funder? How will we assess the movement in any risk within that portfolio? And then we also look at the law firm. If it's going to be a large number of cases, do they have the capability to manage that? And you know, I think there's been sort of discussion around sort of IT systems and platforms that should be in place to help with that. But how are mistakes going to be avoided or minimised in the management of the particular portfolio? And then I think finally, just security. Is security on offer? What's the security? Is the security within the portfolio itself, and the stronger cases, you're going to use those, and the returns against the weaker cases, how does the waterfall and deployment look? So quite a lot of different considerations than if you're sort of diligencing a one-to-one case.
Mm-hmm. Alex, from Northwell's perspective, do you see other challenges in terms of portfolio funding becoming a more widespread product?
From our perspective, and we are, as I said at the beginning, a more of a generalist special situations investor. And our perspective is to try and make our investments, even the litigation funding, look as far as possible like a credit instrument with downside protection. Clearly that's a stretch, certainly with a single litigation, for example. With a portfolio, I think you can get a little closer to that. Mm-hmm. And some of the things that Maurice and Emily have touched upon are important in that. Obviously, the most important one, which has been mentioned a few times, is the diversification and cross-collateralization. What we try and do is find portfolios or enter relationships, be they joint ventures or corporate loan facilities, where there's a variety of risk, a variety in terms of duration, jurisdiction, case type, legal basis, etc., and ideally uncorrelated as well. So really basic, modern portfolio theory stuff that we apply to any other type of investment, and I think that's the kind of fundamental benefit from our perspective. The challenge, of course, is, I think, as Maurice said earlier, underwriting all those different types of risk. Litigations in far-flung jurisdictions. A barrister never tells you that they're going to lose the case they're fighting, and so you have to do as much work on one case, whether it's in a portfolio or whether it's outside of a portfolio, which can be a substantial amount of work from your team internally, be they lawyers and financial analysts, or the law firm you're working with, or QCs that you're getting opinions from, or whatever it might be. The other aspects, I think, that can be challenging are scaling. There is a overhead associated with running these cases. A couple of people on the panel earlier talked about how expensive lawyers are. And of course, that's the major cost. One benefit of portfolios or a relationship with a platform or a law firm is that you can try and set up a structure that's more aligned than it might otherwise be. So as a funder, you can perhaps have less upside, but in exchange for that, have less upfront cost, for example. And then finally, I think one of the things that is challenging with these structures is that you are exposed to the operating costs of the entire portfolio, whether you like it or not. You're not isolated from those. ATE comes into play, and I'm sure we'll talk about that later. But a number of different risks we look at in trying to make it look more like a legal asset than an individual binary risk litigation.
Yeah. And Maurice, in terms of a commercial law firm, how much risk would you expect the firm to take on? I know firms are all about de-risking a portfolio or a part of their balance sheet, but obviously there has to be an alignment, as Alex said. What are you looking for the commercial law firm to do in terms of being a serious enough investment that you may want to go side by side?
I think different law firms want to do that in different ways. Some are much more comfortable taking risk than others. And it's interesting, I think, in the UK, certainly seeing an increasing appetite for risk amongst UK law firms. US firms are well used to running firms on 100% contingencies or maybe a smaller amount than that. But they're comfortable with risk, and they're comfortable at assessing that risk in order to get the considerable upside that can flow from it. For Harbour, I think it will differ between funders. For Harbour, there is no limit. If you want 100% of your fees paid, that's fine. There will be the usual thing which was being talked about earlier about scrutinisation of budgets. I think if you were to have a law firm that says, we obviously need to pay the bills, we need to pay our staff, we need to pay for our beautiful conferences in lovely venues, that's no problem for us. And I think, if a firm is saying, can you pay us 60%, 70% of your fees, that's a meaningful investment, I think, in the litigation. So it will differ, I think, between funders. It's a question of finding that balance, as you say, Bill, between, the amount that a firm needs to, ensure its costs are paid, but also, being able to share on that upside. And generally, I think what we see, it's that profit element for law firms that they're often willing to forego in order to get some benefit from a case at the other end.
Yeah. Emily, in terms of process, as a law firm leader, we'd like to think that we can facilitate the onboarding of clients to accelerate the process. Would portfolio funding truly help do that?
I think we've seen, some requests from law firms to look at their book and to look at the portfolio funding offer, because it could help you to be more competitive in the market. I don't know whether that's true, and I don't know if you have sort of exclusive arrangements with certain funders, whether that's a sort of an ethical issue. So it's a question mark. But I think, we have seen opportunities, but you need to look at the kind of the track record of the firm. Which side have you traditionally sort of been working on? What's your success rate? What's the book at the moment? What's the capital deployment looking like? So are we kind of back funding from a particular point, or is it just going to be sort of capital deployment going forward? But I think in terms of, putting forward a portfolio, it's sort of all of the points that I sort of talked about earlier in terms of the due diligence and really understanding what's in there and being able to present things so that you can get a quick decision.
Yeah, so I can understand how a portfolio could be, as Alex, as you said, there's a tremendous investment that goes into any type of funding, but particularly a portfolio. Do you see it feasible to go beyond, say, a portfolio of competition cases and go across the board in a commercial law firm generally? Or is that just too much due diligence to make it feasible within your appetite?
I think, well, it depends. I think, somebody mentioned on one of the panels earlier that, as a litigation funder, if you have a 75% success rate or a 65% success rate, then you've priced it accordingly and you're doing well. I think you can construct situations where if you have a portfolio of 50 different cases, you're covered with 2, 3, 4, 5 successes, because they're all big risks and big returns. I think in that context, of course, you would be happy to have a tail of cases which you may not have been able to underwrite fully, but only provide upside exposure, or if you like, insurance, should what you've underwritten fail to perform. Mm-hmm. You'd have to look at the adverse risks that you're taking on potentially as a funder, but would you take upsides, additional upsides, where you haven't been able to underwrite those risks? Yes, absolutely. Typically when you're looking at a portfolio in other contexts, whether it's NPLs or real estate or something else, you wouldn't necessarily underwrite every line item. You'd underwrite the big tickets and the big exposures, and you'd accept that there's a bit of a tail which is unknown. So that's, I think, how we look at it.
And can I add to that? I mean, I think you know, you can. Funders are in the business of taking risk, and funders who've been doing it for a long time are sophisticated in terms of how they view the risk. So I think, as Alex has said, there's insurance products, there's ways in which funders mitigate their risk. So I think there is a way in which you can have this sort of mixed diet of cases within a portfolio. And I think we're seeing that especially with you know, those firms that are willing to take on more risk. I don't know, Adrian from Benchmark might have mentioned it earlier, but you know, they have a facility with Gately, which is running cases on DBAs. Harbour have a facility that we put in place with Moderator. And I think for those sorts of cases, I mean, certainly in the Harbour example, it's, you know, general commercial cases of different sorts. And I think there, what we're really doing, it's cases being run on a DBA. So it's cases where the firm are taking quite a lot of risk. We're helping them mitigate that risk. But I think what you're really investing in is the sort of risk appetite of the firm, and you know, there is a process that we have in our portfolio arrangement whereby they join our investment committee. So it's a collaborative approach. The firm is taking risk. It's sitting with the Harbour Investment Committee, and together we're looking at these cases, and there's a sort of real exchange of experience and knowledge. So I think that kind of a structure does help you, you know, open up your appetite for cases of different types and having that kind of mixed portfolio you're talking about.
Just one other thing I'd add, Maurice, as well, is that, you know, the firm is taking on risks, even in relation to the cases that you might not be underwriting. And so from an operating risk perspective, you do need to understand what those risks are. You know, you hear about firms, big name firms, that are in financial difficulties, or you know, certainly we know firms have gotten into trouble in the past. So really, you do have to take that sort of approach. You know, even if you're doing a single litigation, if we're investing in a widget manufacturer, we'll obviously make sure that the operating business can continue to manufacture widgets. I think you need to do the same with cases.
Well, as you said, it is asset-based finance at its core, and you have to be sure that the issuer is sound itself.
Fundamentally, that's absolutely right. And you know, this session isn't about, you know, restructurings, but you know, when we look at an NPL portfolio, we always ensure that the NPL servicer can service those NPLs, and that there's a backup servicer that we can transfer those NPLs to. So those factors are a consideration for any platform or law firm that you're working with, or even a claimant if you're working directly with a claimant.
One issue that we're seeing quite a bit is the issue of disclosure to courts, judges requiring, with a fairly broad brush, to understand all the litigation funding involved in a particular series of litigations. For example, in the U.S. opioid litigation, which is, I think, the largest pending litigation in the country, and in a lot of respects, the judge, sua sponte, issued an order requiring every party, hundreds or thousands of parties, to produce in camera their litigation funding arrangements. And then you also have the risk of disclosure to adverse parties and how that could be used at trial if not kept. Have you, maybe Emily to start, or have any of you dealt with these issues, and have you found any good ways to deal with the issues of disclosure and the risks presented by that? I know I'm hitting you fresh with that one, but.
I think, well, I haven't come across that. Most of our funding so far has been in continental Europe, so the disclosure requirement's very different there. But I think, you know, if that's something that the court requires, and they need to see sort of the underpinning, you know, provided you have a good commercial agreement in place, and that there's a reasonable basis for that, I can't see the difficulty.
Would you be prepared to have the commercial terms of your financing produced to a court if that's what was required? Because I think that is one of the risks, that the courts will want to understand the effect on the litigants of their arrangements, and would require not just to know whether there is funding, but the details of that and how it could drive party behavior. I don't know. Yeah, I'm opening it up to the panel more generally. Because
Yeah, look, I mean, I think, like Emily, Harbour hasn't experienced that sort of application for disclosure of either parties' documents or our funding arrangements. I mean, certainly funding agreements, there are some jurisdictions where you're obliged to disclose that. I mean, I don't know. I guess it will depend on different funders have different views, but I mean, I think at Harbour, we're fairly agnostic about that. It is disclosed in certain jurisdictions. Obviously it's commercially sensitive information, and it may be that we heard earlier about, companies funded corporates not necessarily wanting the market to know that they've sought funding. And so there are things you can do, confidentiality agreements and common interest privilege type agreements that mitigate that risk. I mean, it's quite that there's an interesting difference, I think. You see courts getting, and indeed in jurisdictions like Australia, regulators getting very exercised about litigation funders, and less so about, firms that may be working on risk. Now, essentially, a firm working on risk is a type of funding arrangement, and yet they don't seem to be, too concerned about that. I mean, I take the point. It's really about the sort of undue influence that might be brought to bear by a sort of party that's not involved in the litigation and has a commercial interest in it, but law firms do. I think as well, I mean, certainly in the US, we often encounter law firms saying, well, we'd like you to fund our case, but we can't tell you very much about it, or we can't give you any of the key documents because, we're very concerned about disclosure. And I do think, that's overstated, that risk, and I can't now remember the case, but I will look it up and I'll send it through to Brown Rudnick, or I'll find it in the break. There are some good recent cases where, courts in the US have been saying, yes, you can make the application. It's a lot of defendant tactics, I think, often. Yes. And, it's not necessarily resulting in these sorts of arrangements being disclosed.
Mm-hmm. I think, there's a good question there around, let's call it a sort of a red face test. I think, and anything you enter into, both ethically and for the reasons you mentioned, should pass that test, vis-a-vis a court or the claimants, or your counterparty. You certainly see some interesting structures perhaps coming over from the other side of the Atlantic that are quite full, shall we say, in terms of returns. And one debate we were having internally the other day when we saw something was the amount of the proceeds that were going to the non-claimant parties compared to the proceeds going to the claimants. And there may well be an issue around that ultimately when I think when courts look at this, whether it's a technical requirement or whether it's in certain jurisdictions in continental Europe, where the judiciary may be a little bit less rules based and in some cases take a view. More of a political view on the subject.
Yeah, I mean, sunlight's a really good disinfectant, and so if more funding agreements are out in the open, I don't think that's necessarily a bad thing. I think it's, if you feel that a funder is taking too much of a share of your recoveries or your clients' recoveries, shop around. There's plenty of funders out there now. There's competition between funders, and therefore, there is a conversation to be had on pricing. So, if the terms are rich, don't hesitate to, speak to somebody else.
Maurice is cheap and available.
On the another risk that we try to deal with from the law firm perspective is the extent of disclosure. Alex, you talked about underwriting, how labor intensive that is. It must be, and it should be. Yet there's a tension with the law firm client to be incredibly careful to not disclose anything that could be considered the waiver of a privilege. Where do you guys see the tension with your clients, your customers, and that playing out? And can you get the information you need to truly underwrite, given the important need to protect the privilege?
Yeah, I mean, if we can't get the information, we won't underwrite. But I mean, I do think that, there is a kind of common interest here. And I do think, funders good funders are quite specific in the documents they want. We absolutely do not want a data room. Do not give us huge volumes of material. We want to know about recoverability. We want to know that you've brought these cases to a successful conclusion before. We want to know how much you're going to spend, and we'll need to know something about the merits. And that really needs to be not much more than a good legal opinion from you, and maybe a few supporting documents. So I don't know that we will necessarily be wanting to see all of the really hot documents in a case that, if they were disclosed, would cause real problems. There is information we need, and there has to be a conversation about it. But yeah, I mean, I think we're kind of very sensitive to the issue of disclosure and not wanting to cause any jeopardy to the case.
I think that's right, because at the end of the day, our interests are aligned. So if we're going to invest in the case, then we don't want to have jeopardised it up front. But I think, there has to be some trust between the funder and the law firm and the client. And if, and if documentation or key parts of the case are withheld, that obviously impedes the underwriting. But, there are ways to sort of structure the due diligence to streamline that. So having discussions around sensitive areas, rather than, requiring a full set of documents for that particular point, are ways that, we can really get our heads around what's going on. But again, at the end of the day, the interests are aligned. So, we want to make sure that there's no jeopardisation of privilege and waiver in respect of the case if we're going to fund that.
Yes.
You could also make good use of independent counsel. So independent counsel might have a look at those documents, and there might be sort of lawyer-to-lawyer discussions between you as the law firm seeking funding and an independent lawyer that's paid for by the funder. And so that independent counsel will report to the funder, but the funder doesn't necessarily need to see the documents, but we could rely on their advice.
We would almost always do that as well, because I think it just makes a lot of sense. But the whole purpose of this particular discussion is about portfolios and the risk mitigation that comes from that. Clearly the broader and more diversified the portfolio, and the more aligned you are with the law firm or the platform, the less you should be concerned about those things.
Yes. And especially with portfolio fundings, you could, I suppose, reach a level of relationship with a law firm that you could get some good information regarding how they are about budgeting and what their investments are, which is a critical aspect to success for both the law firm and for you. Have you been able to reach deep enough into law firms to get good information about how they are at running litigations according to a budget, or what do you see that should be done better in that regard?
Absolutely, I think that's fundamental. People used to say that law firms run by lawyers are not a good idea, and these days law firms have professionalized. They have COOs and CFOs and other senior officers who manage budgets and the operations of the firm, and that's for good reason, because if you have a litigator deciding where to spend the budget, he or she will want to go after the next big exciting case. Inevitably, that's their job. And so part of it, from our perspective, is to add some of the discipline that a credit investor adds, which is looking at simple things like ROI. This is an interesting case, but really, will it return capital? Is it worthwhile for the firm? Is it worthwhile for us? Is it worthwhile for the claimants? And we need access to that sort of information. You might take a different view if you're funding a single litigation within a very large and stable organisation that's very well funded, but that's not what we're talking about on this panel necessarily.
I think I'd agree with that. I think for portfolios, data is everything. And with apologies to the lawyers in the room, law firms are often dreadful at keeping data and keeping their own records. And you get to the end of the case, you see, you look at the total bill, well, we charged this on a case, that was a great result, wasn't it? I mean, I think if law firms I think, much better in the States because there's so much risk, personal, financial risk to the firm of working on contingency. I think if UK law firms do want to do more on DBAs or other arrangements, then having the data on how you've run those cases yourselves is really, really important. And I would advise any law firm just to have a few people assigned to work on this as a little project over the summer, just to look back at cases. What was the claim value at the beginning? What did it end up settling for, or what did you win at trial? What was the budget initially? What did the budget end up being? At what point in the case did we settle it? If you have that kind of data that you can present to a funder when you're seeking funding for a portfolio, indeed for a single case, it's really, really useful, and it makes the whole decision much, much easier if we can see that sort of track record. And I think if you're working on risk as a law firm, it just gives you a really clear indication of the level of profitability you might see from those cases. And quite often, firms just don't have it. And it would be really helpful if firms did have it and kept it as a matter of routine. We are seeing as well the emergence of data analytics programs. So litigation data analytics is a really interesting area. And it's not so much, I think, going to show settlement values. A lot of those are still confidential. But it will give a sense of duration on cases, on success rates. We can look you all up, law firms. That data is out there. We can see, who managed to settle those cases early. So that kind of data is really valuable for funders.
And I think when you're sort of looking at the due diligence up front, and if it's not a firm that you've worked with a lot before, you can get some idea around their budgeting through looking at what's actually been presented, because, portfolios are more difficult, but on a one-to-one case, we kind of have an idea of what the budget should look like and what the profile of spend would be. And if it's not really within tolerance what the law firm have presented, then I think that's a red flag in our due diligence.
It's a very, it's a very complicated business these days, running, a group action a case or a law firm, because it's not just employing solicitors. It's also going out and marketing and book building. It's processing those claims. It's managing those claims. There's a call center. There are solicitors. There are external parties, barristers, a whole slew of things. So depending on the number of claimants and the number of cases and all the different aspects that go into that, it's hugely complicated. And so you need a very sophisticated CFO and treasury team and software to manage all of that. Yeah,
managing that is really important. And we see lots of budgets. We can, if we see a budget that looks light, we think, well, it makes you question the judgment of the firm if they can't quite anticipate what might be coming down the road in this type of a case. And portfolios are made up of individual cases after all. So I think we'd much rather see realistic budgets that account for everything that might possibly go wrong in a case, rather than something that's too ambitious. We're unlikely to fund something because it's got a cheap budget. We want to know that it's got the right budget.
Well, and to be able to include in your conversations, especially when you're putting in all the work to consider a portfolio, to bring the chief pricing officer or others beyond just the partner in charge, I think would be an important step. And I just don't know whether you see, Emily, for example, law firms receptive to that, to putting other people in the room and not just the partner who sponsors a case?
Sometimes. I think it depends on the size of the firm, what they're bringing to you, what the size of the investment is. But often it is the partner that's doing the negotiation, and then as we've discussed, there are varying degrees of complexity in terms of their budgeting process and what's gone into preparing the materials that have been presented.
There is an inherent challenge which I'm not sure has been solved yet, because sometimes we speak to a COO or a CFO who comes from a different industry, because this is a novel business in many respects, and because they don't really understand the cases and the assets, they will just take all of the information from the partners who are running the cases. Yep. And so it's not quite the quality of information and management that you would like. Yeah. It's a challenge.
Just didn't want to leave a minute or two to try to stay on time. Any questions for our panelists?
Can I ask a question?
Yes, Tubi.
Alex, you spoke about portfolio, and with that comes reduction of risk as a function of collateralizing your recoveries. do you return that to your client in the context of different types of pricing when you extend the financing?
Well, yes. I mean, theoretically, you should price it cheaper for a lower risk product. What we look for our LPs ultimately is asymmetric risk reward. So, frankly, we're in the business for the pensioners that invest in our fund of reducing the risk and increasing the returns to a level, that is attractive. There is competition in the market, which is great. There are a lot of players in this space now, in this room, on this panel, and that's good for everyone because you get to a level of market pricing. So yes, is the short answer to your question, but it's not necessarily always as cheap as counterparties think it might be, because the cases that are dead certs for the partners that are running those particular cases may or may not be, and there may be risks that we take into account. For example, somebody might consider that a case is going to absolutely settle, and for there to be no duration risk. But as we know, litigation rarely plays out as you expect. But in broad terms, absolutely, there's an inherent lower specific risk that comes with these cases. For example, airlines settle data breach cases even though their planes are not flying in the middle of a lockdown because, fundamentally this is the sort of thing that they have to pay. Or diesel emissions, car manufacturers caught up in the diesel emissions scandal, even though they can't make cars because there are no silicon chips coming from Taiwan and no wiring looms coming from the Ukraine, will settle those cases because it's not really a market risk type asset. Mm-hmm. So we like the risk of the portfolios, and we think the pricing should absolutely be lower than a single case risk, for sure.
Others? Yes.
From a UK regulatory point of view, thinking of the lawyers and maybe the FSA, what are the risks of a portfolio funding in the UK?
I think if it's a funding arrangement, generally I think we've encountered there are no particular issues. There are often tax considerations depending on how the funded party is structured, whether they're a corporate or an LLP. So there'll be those sorts of things you would want to take advice on. It's not lending, it is still principally non-recourse funding. And so, I think the regulatory regime is lighter. That's just our experience, I don't know.
I think there are some risks that, we are cognizant of. You've got to be careful with the level of control, of course. And that's, there's case law on litigation funding, but more generally, law firms clearly have obligations to their client and the SRA. So we try and let law firms get on with their job and not interfere in that. Clearly, there's technically speaking a risk of misalignment of interests with a particular group of claimants if, for whatever reason, you'd prefer to pursue one of the other cases in the portfolio and you can take a loss. And that's something we would want to step back from and ensure that the lawyers who are working for their clients are doing the best possible job for those clients, both ethically and technically from a regulatory perspective.
I think also to that, when you're dealing with a commercial law firm and a portfolio and then a broad spectrum of assets, the intercreditor agreement with the law firm's working capital lender is important to really understand and to make sure your assets are first on your investment. Yes, there was another question.
Yes, hi. My question is and a little bit in line with what Maurice was saying before about this is a competitive market. Do you think that as portfolio financing continues to grow as a product, we will see more and more bidding process or auction process for these portfolios? And if so, is the industry ready to forego on exclusivity during the due diligence process?
Yes, and yes.
Perfect.
I think we definitely are seeing more tendering for cases, and there's a lot of use of brokers. There are some really excellent brokers in the market. I suppose one thought on brokers: they don't necessarily work with all funders. A bit like compare the market, doesn't necessarily have every insurer on it. But I think, yes, we're seeing more funding. I think in terms of exclusivity as well, generally speaking, I think most funders will seek exclusivity at the point where there's terms agreed. And so for the purposes of investigating a case, it may be that a potential funded party discloses certain information about the case and seeks indicative pricing. That indicative pricing can be put forward, and then there's probably a phase 2, which is a bit more of a detailed dive on you know, the kind of merits of the case. So I think for that first stage, no problem, no exclusivity, it shouldn't be an issue. If you're wanting to, you know, take a number of funders through to the second round, that might be where you have a bit of a discussion with your funders about whether or not they're prepared to remain exclusive at that stage. Non-exclusive, sorry.
Okay, I think we're pretty much at the end of our allotted time. If that could be okay, we'll keep the trains running on time. Emily, Maurice, Alex, thank you very much.